Hello, everyone. Thank you for tuning in today. Welcome to Sign for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in personal injury, product liability, workers' compensation, trucking law, rideshare, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. In today's episode, I have a pleasure to be talking to the attorney Samantha Cohn with the Smith Law Center based in Hampton, Virginia. Samantha, Hampton Roads native, holds a bachelor's degree in history from Old Dominion University and jury doctor from Nova Southeastern University. Licensed in Virginia since 2015, so for the last 10 years. She has conducted over 1,000 trials and can practice in Virginia state and select federal courts. Based in Richmond, Samantha enhances the firm's services across the state of Virginia while enjoying time with her husband and 3 boys, as well as traveling, golfing, and practicing yoga. Today, we'll be talking about the importance of medical treatment in personal injury cases, recent legislative changes in Virginia, and provide practical advice for plaintiffs navigating the legal landscape. At the end of our episode, I prepared fun pop-up questions, so stay tuned. Welcome to Sign for More Injury Funding podcast, Samantha.
Hi, thank you. Good afternoon. Thank you for having me.
Can you please tell us a bit about your background and what led you to become a plaintiff's trial attorney at the Smith Law Center in Hampton, Virginia?
Absolutely. So I grew up, we're Jewish. So the joke is we were either lawyers or doctors. Those are our 2 options. And I started out school as pre-veterinary medicine, and then I hit physics and organic chemistry and jumped off a cliff and grew up with a family of lawyers and grew up very close to my father, who's a prominent energy tax attorney. And so I decided that that was the route that I was going to go. I get too emotionally involved to be a criminal attorney. And so by being a personal injury plaintiff's attorney, I'm able to fight for justice and give my clients a voice and try to make things as right as possible after they've been injured due to somebody else's negligence. So I really take it as a privilege and honor that I can bring them some justice and closure and help them move on with their lives.
Beautiful story. Thank you for sharing that. How many attorneys do you have at your company right now?
So we currently have 7. We have the 2 senior partners who are Stephen and Howard Smith. Their father actually started the practice back in 1949. And then we have the junior partners, David Holt and Stuart Gill, who I will say all 4 of the attorneys are still active and practicing. Howard's probably going to kill me for saying this. He's 80 years old and he still goes to court.
I love
So,
it.
yeah, all of them are in court all the time. And then we have myself as an associate, another associate, Catherine Carroll, as well as Emily Strack as a new addition to our firm.
Wonderful. What are the primary areas of law that you focus on, and how do they relate to personal injury cases?
So I do focus on personal injury. I am a personal injury attorney, mostly for car accidents, occasionally for the premises case, such as a slip and fall in a grocery store. I have actually started to dabble in medical malpractice with birth situations, which is heart-wrenching, but most certainly the most privilege I could have as an attorney to fight for these families and these babies who have been injured and sadly have even passed away during negligent birth and delivery, but mainly car accidents. So I practice day in and day out personal injury, and we focus primarily also on traumatic brain injuries. We're actually the Smith Law Center and the Brain Injury Law Center. Stephen Smith, one of the senior partners, actually was the pioneer in traumatic brain injury cases and the invisible injury, because it's not like your arm where you see it's broken and in a cast and you have to have surgery. Even with typical imaging techniques such as MRIs and CAT scans, even then you're still not really picking up the nuances of traumatic brain injuries. So we have really honed in on that niche and really formalized how to present it to a jury in the most effective way to get our clients the most compensation that they deserve for what they've been through. Because for several of them, it's essentially that the old person who was involved in that accident has died, and the person who is now present is completely different in preferences and behavior and moods. And so, for instance, David Holt, with the managing partner, was out in Oklahoma for 8 weeks this past summer for a TBI injury case, resulting in a $10 million verdict. But we do general personal injury, but also specialize in traumatic brain injury.
Very well. Let's jump right into the importance of seeking treatment. Why it is crucial, in your opinion, Samantha, for plaintiffs to seek medical treatment immediately after an injury?
It is paramount for personal injury victims to seek treatment as soon as possible after they're in an accident or after they're in an incident, a slip and fall or anything of that nature. I'm not saying that every single time you have to have an ambulance come to the scene and you have to get in an ambulance and go to an emergency room. Most certainly that's costly, that's time consuming. Also, everything doesn't warrant an emergency room, but maybe a minute clinic or a walk-in clinic and urgent care or your PCP as soon as you can get in, which I know for most of us is like you're sick and you call and it's 6 months down the road. So it's not very helpful. But it is important to get that diagnosis and that present sense impression for that provider. If it is a catastrophic accident, to have that emergency room, to have them describe what you look like, the bruising, because obviously that fades. I have a woman who just came in the other day who hit her head on the steering wheel and she's got a huge black eye and her eye is full of blood. Well, by the time we get to trial, that's going to be gone. And so to have that recorded in a note or a record from a doctor, yes, you can come in and enter testimony and evidence about what you've been through. However, to have the medical record corroborating that and having that diagnosis and starting that treatment as soon as possible is key, because the defense is always going to attack and say, well, if you didn't seek immediate treatment, you couldn't have been that injured. It must not have been that bad. And if there are gaps in treatment, you're going to have to fill those in and explain why, and a judge or a jury is going to have to believe you. And I'm not saying that there aren't valid reasons, but most certainly having a congruent track chronologically from the time the accident occurs and having immediate care and continuing care is the key for setting yourself up for a successful personal injury case.
Thank you so much for explaining it and so thoroughly. How does the timing of treatment impact the legal process and potential compensation for clients, from your experience?
So in Virginia, typically when looking at what a settlement or verdict should be for a personal injury case, it's going to be roughly 2 to 2.5 times the medical bills. So quick and dirty math, because I'm not a math person by any sense of the word. You say you have 10,000 in medical bills, you'll be looking at a $20,000 to $25,000 verdict or settlement generally. Now, if you go to one emergency room visit and you don't have any follow-up, you're probably not going to hit the 2 times. If this is a catastrophic accident that you're going to have lifelong ramifications, the car flipped over multiple times and the person was drunk, you're most certainly looking above the 2 to 2.5 times. But those medical records and those medical bills are typically going to be the foundation. And so when I talk to clients and they ask me, well, how long is this going to take and how much money am I going to get? And I tell them immediately, I don't know. And any attorney who tells you that they know is puffing smoke. We don't, because it could be a situation where your shoulder hurts. I have a client like this. His shoulder hurt. He went to urgent care. He did one round of physical therapy. Well, it turns out he had a rotator cuff tear. So after the physical therapy didn't work out, then he had some imaging done, had surgery and another round of physical therapy. If we had cut it short at that first round of physical therapy, he would not have been properly compensated. So the way that the legal process works is I need to follow my client's treatment. If I try to run to the courthouse or get it settled prematurely, they're not going to feel back to 100% or close there too. And they're not going to be fully financially compensated because they're not going to have those bills that are generated from that subsequent treatment. So when I explain it to a client, I tell them, I'm just tracking your treatment. We have 2 years. I got to see what happens. I got to see where you go. And if it comes up to those 2 years and we need to file to preserve your statute, at that point, we're usually engaging life care planners, vocational experts to project out that future care. But it is most certainly incumbent upon me as a personal injury attorney that I need to monitor, and the chronology of the case and how the case proceeds is on that treatment and their treatment plan, because I don't want to shortchange them and I want them to feel better and I want them to get the proper compensation.
And it's interesting talking about the timeline or the amount of money that potential client can win. I was in symposium yesterday of Fred Goldberg, a very well-known trucking attorney group in Buckhead, Georgia. it was the best of the best. So they were the best, we discussed the best verdicts of 2023 and 24. And it came up in the discussion or during the presentation, exactly that, that you cannot tell, unfortunately, or fortunately, unfortunately, but the reality is you cannot tell your client, how soon the case will settle, will have to go to court and trial, or, the actual outcome of the case. So that's a good point. A plaintiff seeks treatment. What constitutes proper treatment in your experience?
What constitutes proper treatment would be treatment appropriate for the injuries with the right provider. You obviously have to look forward to this matter going to trial. I don't want the matter to go to trial. I want my client to feel better. I want the insurance company to treat them reasonably. I hope they don't have to have a lot of treatment. I don't want them to have a long course of treatment. However, we always have to approach the treatment from the aspect that at some point we're going to need an expert in a seat to talk about their injury. So we have to make sure that they're with the right doctors. Now, I'm by no means a doctor. I'm not a medical expert. I don't dictate treatment. I don't meddle in treatment. The only time I get involved is if I have a client that says, I'm doing physical therapy, I'm not feeling better. What do I need to do next? Or I don't have insurance and I need to see a provider. What do I do? But we always have to think about it that there's going to be an expert necessary. So if your shoulder's bothering you, but you're only going to see somebody about your knee, they may not be able to talk about the same thing. If you have a TBI, even a concussion is a mild TBI. If you have a concussion and you're going to see somebody about your back, he's not going to be able to talk about your concussion. He's not going to be able to testify about it. So it's very important that I make sure for what are the major or overarching injuries that somebody's experiencing, that we have a medical provider that's able to testify as to the causation, the diagnosis, the prognosis, and how that affects my client so we can make sure to get them compensated for it.
Absolutely. Samantha, can you discuss the role of medical documentation and how it affects a case?
Medical documentation is so significant in a personal injury case. And honestly, the knife cuts both ways. There can be records that aren't great. There's pre-existing conditions, or a client shows up on a certain day and says, oh, I'm feeling great today. We see those records beforehand, and obviously the answer is, well, on that day I was feeling great because I'd just woken up and I hadn't been active, but the next day I was active all day and I was in excruciating pain by the end of the night. But the problem is the jury going in, the jury knows that you have a bias and you have a motive to say the things that you're saying as the injured party. You want to tell them your story, but you also want to get money out of them for it. So they listen to you, but it's really with a grain of salt. These medical records that are provided, that the doctors write and author, corroborate that story and have a medical professional validating what that person is experiencing and what they're going through. And so in some cases, depending on what the injuries are, we may not have an expert, but particularly with these catastrophic injuries and these lifelong injuries, we have many experts, and these records are what we rely upon, what the doctors rely upon, and ultimately what the court relies upon in the jury in presenting these cases. It is the medical documentation that corroborates the experience of the injured party. And I mean, just to be honest, the doctors have more credibility. They have more credence. They're professionally trained in this. So where your client says, hey, my shoulder is bothering me and it hurts, the doctor is going to come in and say, oh, they have this tear, the range of motion is limited, and they can give the mechanical explanation as to why your client's experiencing that and corroborate what they're saying.
And since you work with, specific network of medical providers, or, including orthopedic surgeons, physical therapists, probably mental health specialists, and everybody else in between, how do you advise your clients to choose healthcare providers to ensure they receive adequate treatment?
So, really the advising of my clients comes in kind of when we're discussing how they're feeling, what's going on. If they have a doctor that they're comfortable with, I want them to stay with that doctor. I appreciate having that explanation of the continuity of care, that I've been seeing this person before the accident and this is what they had and this is who they were. And then post-accident, this is what's going on with them. A good example would be I had a case where a gentleman had arthritis and he was already in active treatment for arthritis, and then he was in the accident. So of course the defense is like, he has arthritis. arthritis. This is all pre-existing. But because we had the same doctor, that doctor could say, yeah, but he didn't have any limitations. I was monitoring him, but it wasn't anything significant. Post-accident, he now has a walker. He's getting injections. He's in there every other week instead of every 3 or 4 months. So I want my clients to go to who they feel comfortable with, who they trust, who they've already been seeing. Now, if they come back to me and say, hey, you know what? I'm seeing this doctor and I'm still having pain in my back and it's not really doing anything for me. Do you have any suggestions? At that point, I may say, have you talked to your doctor about this? Well, no, not really. Okay, well, you need to go back and talk to your doctor and see what your doctor says. But if it continues to be an issue, that's when I do tap into my network and start to say, hey, I've got this guy who's really great with backs. Maybe you can ask your doctor if you can get a referral to him. We do have a couple of providers that we can do a straight referral to. Most certainly prefer not to, because that definitely comes up in court when they ask, how did you get there? Oh, your attorney sent you there. Isn't that coincidental? Sometimes it just is what it is. A person doesn't have insurance. They can't get health care any other way. That's what we have to do. But I always try to have at least a suggestion to help them navigate to the appropriate provider to help them feel better.
That's wonderful. Thank you for doing that for your clients. Why do you believe is consistent treatment important for plaintiffs, not just for their health, but also for the legal claim purposes?
If you do not have consistent treatment, you are giving the defense so many avenues of attack to tear down your case and to not get the full compensation that you deserve. Because the defense is going to say, again, it can't be that bad. If you have all of this pain and you are in such pain and so uncomfortable and it was ongoing, why aren't you at the doctor? Why aren't you telling the doctor this? That doctor treated you for that. Why aren't you telling that doctor? So it is tantamount to have the consistent treatment to have that record that every single week or every other week you're having pain, you're having discomfort, because that 2 to 2.5 times above your medical bills is your pain and suffering. And that helps corroborate your pain and suffering. And again, you're going to have some bias motive. You have a dog in the fight to say, oh, I'm in pain and I'm uncomfortable. But the more professional people that you tell about that, who can put together a package to demonstrate that this is the consistent narrative across the board, that is in fact what you're going through, that it is credible, that they do have these objective tests such as the loss of range of motion, the musculature, the measurements, the nerve testing, things like that. That just shows as a whole what your total experience is. So you cannot really argue pain and suffering and that you are in so much of it if you're not seeking regular treatment. Because otherwise, why would you not want to alleviate that and feel better by going to these doctors?
Absolutely. And I'm sure you encounter quite a few challenges with the medical treatment and continuity of medical treatment. What challenges actually do plaintiffs face in maintaining a consistent treatment regimen, and how they overcome these challenges with your help?
So we absolutely do. We all have lives. And we all have other responsibilities and other priorities. You have physical therapy that wants you to be there 3 days a week, but you have a full-time job and you have a family. Or I have another client who needed to go to physical therapy, but her husband was on the donor list for a transplant for a liver, and he was gravely ill and then got the transplant and then has the recovery period. So she has a big gap where she couldn't go to physical therapy because she had to maintain her household and take care of her husband. So the way that we most certainly try to cut this off is say, hey, if you can't go 3 times a week, can you go once a week? Can you go once a week and make sure you tell the doctor, like, I want to come more often, but I have all these other responsibilities and I'm on time constraints. I can't lose my job. Another problem is, again, clients not having health insurance or the funds to seek treatment. You have a health insurance policy where your copay is $50 a pop and you're going 3 times a week. I mean, that's $150 a week. I don't necessarily even have those types of funds to seek that kind of treatment. So, what we do with those instances is we either move them to a provider that will lien treat and then just send us the bills, or, as you're aware, we seek plaintiff funding. And we do a lot of plaintiff funding. A lot of our big TBI doctors want to get paid up front and they don't take insurance. So, we have to put our clients in the best position. And obviously, it's a cost benefit analysis. We have to make sure the client's going to be able to walk away with something and we don't put them in a hole with the plaintiff funding. But that is crucial also to helping get them to appointments, to either find the lien treating providers or funding sources that we can get them that money up front, get them to those doctors. Another issue could be finding rides that they just don't have the means to even get to the appointment. And so we work with certain providers who do arrange for rides, usually through Uber or Lyft, or with our firm, we have an account with Uber that we're allowed to set up rides for our clients. So there are definitely several impediments that can prevent somebody from getting the consistent treatment they need. However, if they're honest and open with us, normally we can find a resolution for that in a variety of ways.
Wonderful that again they have you, Samantha, to help them out because when somebody gets in a car accident or any type really of personal injury situation, people usually don't know what to do. They're totally lost, stressed out, anxious. A lot of people have PTSD, which turns to anxiety, depression, you name it. So it's I'm sure they're truly blessed and lucky to have you. How do gaps in treatment affect a case from a legal standpoint? We touched on this a little bit, but can you go a little bit in more detail?
It definitely detracts from your possible overall outcome and whatever verdict or settlement you could get. Again, as I've stated, the defense is going to take those gaps and they're going to most certainly try to exaggerate them and to make them as grievous and large as possible. And we always try to get ahead of it. I don't ever want to have a gotcha moment in court where the defense gets me cornered on something that I haven't already touched upon. Normally, we try to bring them up in the forefront and take kind of essentially the wind out of their sails. Again, with this woman whose husband is as now post liver transplant, of course, that's going to be the number one attack that the defense is going to say. They're going to say, wow, you had an 8-month gap in treatment. Could not have been that bad. So when I put her on the stand, before they have the opportunity to question her, I'm going to say, hey, you're saying that you were really hurt after this accident, but you stopped treatment in April and you didn't go back until December. If you were so hurt, why was that? Well, I had to take care of my household. My husband was getting a liver transplant and that had to be prioritized. It was life or death. Yeah, my back hurts, but he could literally die. I'm going to focus on him. So it definitely opens you up to lines of attack that the defense can try to tear you down and detract from your case, but we most certainly try to put you in the best position. But we most certainly try to put our clients in the best position with the best foot forward to have a credible, valid, understandable explanation as why there may be a gap. Now, if there isn't an explanation, I'm most certainly going to look at my client and say, hey, I'm going to tell you that where you may have gotten this amount of money before because your treatment was inconsistent and spotty, and you don't really have a good reason why you didn't treat regularly, it's going to lower the overall value of your case.
Mhm.
I'm still going to fight tooth and nail for everything, but at the end of the day, a judge or jury is most likely going to see it the same way. So whereas say before it might have been 20,000, maybe now we're looking at like 16 or 17 because there wasn't regular treatment that demonstrated the pain, suffering, and injury that this person's going through.
Mm. In your experience, Samantha, how does thorough and consistent medical treatment correlate with the compensation amounts awarded to plaintiffs?
It is almost one for one. It is a direct reflection. When somebody has consistent, chronological, streamlined treatment with the appropriate provider, it most certainly pays off, literally and figuratively, at the end of the day, either in a settlement or a judgment. You're not going to have any argument that there are gaps in treatment. You're not going to have any argument that you didn't go to the right provider. These are the typical reasons that defense uses to tear down somebody's case as a personal injury attorney. Now, that's not to say that you're not going to get some expert up there who's going to say, no, they were healed in 6 to 8 weeks. They didn't need physical therapy and ortho visits and injections. That's not going to change. At the end of the day, the line of attack for that is that they're a paid expert and they're paid to be here and say that. I always use treating physicians. It is very rare that I'm going to use a hired gun because I love to have that argument. I love to say, you don't know my client from Adam, and you read a stack of papers. You haven't even talked to them to know what they really went through. But it is a direct correlation. The treatment and getting quick, proper, appropriate, consistent treatment till you finish. That's another problem I have with clients is they want to early discharge because it's just a lot and it's inconvenient and they don't want to go anymore. And I have that talk with them and I explain to them that you're most certainly welcome to do that, but it's going to detrimentally affect the outcome of this case because you can't claim ongoing pain and suffering. You can't claim ongoing discomfort because you stopped treatment. So you don't have an explanation for that. So it is a direct correlation of the two and why it is so important that treatment right at the beginning, proper treatment and consistent treatment needs to be done if you want to maximize your compensation from a personal injury case.
That totally makes sense. Can you provide any examples where proper treatment drastically changed the outcome of a case? And I'm sure you have several examples.
So they're kind of cases that I've been on the periphery of, but it's a lot of these traumatic brain injury cases. And the reason for that is, again, it's not a broken arm, it's not a broken leg, it wasn't a surgery. You can't see it. It's not a fairly visible or readily visible injury. And so it is so important to get these traumatic brain injury victims to the proper doctors. Most of the time it's not neurologists. Neurologists will do some scans. They'll say, nothing's wrong. I'm sorry you're having headaches. Let's try to medicate it. And after 6 months or a year, they'll say, oh, well, this is your new normal then. And that's kind of it. And that doesn't address the brain fog, the executive dysfunction, the cognitive impairment, the noise and light sensitivity, the frequent migraines. So making sure that these individuals get to neurooptometrists. For instance, I have a case that I helped out on that this woman's field of vision was permanently 20 degrees left. So she couldn't drive anymore. And a neurologist isn't diagnosing that. That's a neurooptometrist that has to diagnose it. A neurologist can't talk about that. So having them go to a neurooptometrist and ensuring that the blurriness, the displacement, people seeing multiple things instead of one. That's a neurooptometrist that one has to diagnose it, two can treat it, and three can talk about it at trial. Then you get them to the proper neuropsychologists who test them. I mean, the first day of testing can be up to 8 hours. It's very intensive. And they put them through all of these practices and practicals and come up with what their baseline was before, what it is now. And it's, processing speed, whether it's reading, whether it's auditory, whether it's speaking, finding not having the right word choice, not being able to verbalize what they're thinking, having that disconnect of what's coming out of their mouth versus what's going on in their head. And again, that needs to be a neuropsychologist, first of all, to diagnose it, to treat it, and then to come and talk about it as an expert. And then once we have that in place and that treatment's been going on for, say, a year, then we start to bring in vocational experts because a lot of these people can't ever work again. Another case that I'm working on, she was an F-18 simulator, fighter jet simulator instructor. So she's staring at screens all the time and everything's coming at her super fast and it's so many things that she's got to do all at the same time. She can't look at computer screens anymore. Her job is gone. And so we have these vocational experts that then project out the loss of income from losing that job. Then we have a life care planner who comes in, who's going to project out all her future medical costs and future medical treatment. If you don't get these people to the proper doctors, that's potentially millions of dollars, millions. And most certainly it has to be the appropriate case. It's not going to be a case where both parties have the Virginia minimum limits of $30,000 and we're going to put them with these experts that are $12,500 right off the bat. But to have a case where it's a commercial entity, a truck driver, something like that, and have thankfully that amount of money, But if you don't have them treated properly and have the right experts lined up, it's millions of dollars that you are not garnering on behalf of your client to properly compensate them for now this entirely new life that they have to adjust to.
All right, let's redirect our attention to legislative changes in Virginia, which took place in about 2023, 2 years ago. What are those changes regarding personal injury cases that have come into effect in recent years?
So in 2023, the Virginia Trial Lawyers Association, which is mainly comprised of, I believe, plaintiffs' attorneys, they actually lobbied to have the stacking of underinsured and uninsured motorists changed, because what it used to be is, say both individuals had minimum policies of 30 and 30, they canceled each other out. So you were only able to get the $30,000. Now, what it is you can stack your 30 on top of the other 30 for a total of 60. And it is totally proper and appropriate because you're paying for that coverage. You're paying the underinsured and uninsured motorist provisions on a monthly or annual or biannual basis. That's money that you're paying to have access to. So before, if somebody had 30 and your policy was 50 and they caused an accident, you could get the 30 and then you could get the additional 20. Now, again, you have the 30 and you can stack the 50 on top. So that started in June of 2023 for policies that were either started or renewed after that point. So now we're really coming to the fruition of that, where the personal injury cases that occurred after that point are starting to settle or go to trial. So it's becoming more prevalent. And in order to opt out of that, which insureds do have the option to opt out, but they have to do it in writing and they have to sign something. So it is incumbent upon an attorney to ensure that it is stacking. And if they're arguing that it's not stacking, that you get that piece of paper that your client signed that said it's not stacking. Because you're at minimum usually doubling what your client can get at most. And it's very important to get them that full compensation if it's deserved.
100%. How do these changes impact the way plaintiffs should approach their cases moving forward?
So it used to be a case where if somebody only had a $30,000 policy and say they went to an ER after a horrible accident and had all this imaging done, that's gone. The 30's done. You know, the insurance company is going to say, here's my money and get out of the way, because they can't do anything else. We most certainly don't want our client to continue treating because we don't want them to have more expenses with this limited amount of money due to them. Now it's changed because our clients can, I shouldn't say I don't want my clients to treat. They have to stop treating till we get the money and give it to them. And then they can continue treating, because then liens can't be placed against that money. However, now we're able to ensure that our clients can get more proper and monitored treatment because they do have access to more money. So there are still certain cases where the ER bill is just that egregious that we have to get all the money in immediately and then get them out. However, it does lend itself to continued treatment and continued representation, because it makes sense that we aren't necessarily just asking for a tender because there is so much more money. So it allows them to get more treatment, and it allows them at the end of the day to get more compensation, which to make them as whole as possible is always the name of the game.
Are there any specific provisions that you believe plaintiffs should be particularly aware of when navigating the legal process?
So there is another provision that just came about in 2025, and it's a big deal to Medicaid holders. It used to be that we would get Medicaid recipients, and the liens to get the end, or I should say, to get the final lien from Medicaid took forever. I mean, sometimes over a year. And so again, the VTLA had petitioned and they got a change to the legislature. It's 8.01-66.9:2, where now Medicaid has 60 days to respond to us once we get a lien, once we request the final lien. If they don't, we can send them a proposed lien amount. Now, obviously, we have to be reasonable. If it's supposed to be $5,000, we can't send them $100 and be like, okay, thanks, have a great day. But we have to be reasonable. We send them this lien. And if they don't respond to us from that in 45 days, then it's considered to be fully acquiesce to, and that's the final lien amount, that they have essentially accepted that as the amount that the lien is constituted. So that's a huge change, where it used to be that my clients would have to wait around, that we overestimated this lien and then we're waiting for it to come in and they're due more money and we need to give them more money, but Medicaid's not getting back to us. So where a person used to maybe previously not use their insurance and their Medicaid coverage because of this lien, they're now able to do so in a more timely manner, get that final amount, and resolve their case sooner.
Now we'll be talking a little bit just briefly on Medicaid procedures. Can you explain the new Medicaid procedures that were implemented in Virginia in 2023?
Okay, so as I just stated, the new one is getting the lien within 60 days, and it's just going to much more expedite and streamline the process and get our clients all of the money that they're due as soon as possible. So while we hold the money in escrow and we always overestimate, this way our clients have access to it much sooner. I'm interested to see, and my hope is that the personal injury attorneys are reasonable in these proposed liens that they send out after the 60 days, giving everyone the benefit of the doubt, because if they're not, it is going to revert and we're going to be back to on Medicaid's time, and that takes forever. So it is very important now for the clients, again, seeking the proper treatment. They can utilize their insurance and they're going to be able to totally close out their cases much sooner than they could before.
How are these changes affecting plaintiffs who rely on Medicaid for their treatment?
So the changes affect the plaintiffs who rely on Medicaid for their treatment, because unlike before, where we may refer to them or tell them to not use their Medicaid insurance, it may limit their providers. There's going to be a lien outstanding. We may suggest to them to avoid having to utilize their insurance, which is typically the opposite of what we usually say. And on the back end, it affects them, because where we used to have to wait an extended period of time for these liens to resolve, they're now going to have answers much quicker. Again, we always hold an extra amount. We always hold over what we estimate the lien to be. So that's extra funds that go towards that client and the closure of their case. So they're going to get more money and they're going to get it faster, and their case is going to be closed and resolved much quicker than it used to before.
What should plaintiffs know about how these procedures can impact their case and potential compensation?
So the two statutes that we talked about together have a huge impact on plaintiffs' cases. First of all, the stacking statute, again, opens up so much more compensation to them than previously. It used to be that you were limited to either nothing, depending if the policies were the same amount, or the offset of the liability policy against your policy. So it most certainly increases the amount that they are able to get in compensation when moving through these cases, whether by judgment or settlement. Now, the Medicaid, again, is just going to allow them to get more money and get the case closed in a quicker manner than it used to be previously. So in conjunction, the two of them actually have a very serious and significant impact, which just reading them on their face may not seem like a big deal.
Let's talk now about some practical advice for the injured people. What advice would you give to someone who has been injured and is considering pursuing personal injury claim?
What I would suggest is, and I know it's going to sound biased because I'm an attorney, but I would suggest having contact with an attorney pretty quickly after an injury in an incident or an accident, particularly if it's a catastrophic or grievous type of injury that you're having surgery that's going to be ongoing, long-standing nature. I would most certainly have somebody contact attorney right away. That attorney is going to, first of all, take a lot off of your plate. I don't know how other attorneys necessarily operate, but with my clients, all my client has to do is get better. We deal with the providers, we deal with the insurance companies, whether it's health insurance, whether it's car insurance. You have to be very careful what you say to car insurance. Even if it's your own company, they're going to use whatever you say against you. So it's very important that you have limited contact with them to no contact. You obviously have to explain to them how the accident happened. Usually there's going to be a property damage aspect of a claim. You do have to speak with them about that. But when it comes to the nature of how you're feeling, you cannot say anything to them. Most people aren't aware of that. Most people aren't aware that every call is recorded, and we're going to walk into court later, and that defense attorney who's paid by your own insurance company is going to walk up with that log and say, oh, isn't it true on this date you had a conversation with them and you said you felt fine? So it's very important to speak with an attorney to get the guidance necessary to seek proper treatment, to not talk to insurance companies, and to just be able to focus on getting better while we do all the background work on your behalf. I would also tell them, as we previously discussed, very quick and consistent treatment. Go to urgent care, go to a walk-in facility. I don't need you to get in an ambulance at the scene if your toe is hurting and go to the ER. But very within the 24 to 48 hours, go to an urgent care. My neck is hurting, my back is hurting. Another problem with accidents, which a lot of people don't realize, is it's kind of like working out. You're in the accident and you've got this shock and adrenaline. And so you're not necessarily feeling all of the effects of the accident right after it. Usually they take a day or two for you to start to get sore, like when you work out really hard and then your muscles are sore a couple days later. It's not right then, it's not instantaneous. So making sure within 24 to 48 hours you get to a provider, whether it's your PCP, urgent care, walk-in clinic, if it's bad enough, the ER, get your injuries and how you're feeling documented. Have somebody treating you, see what your next steps are. And then take that referral. If they say you need to go to PT, and actually go to PT. I have a ton of clients are like, well, I'm not getting enough money out of this. And I said, well, I had a conversation with you that 6 months ago you were referred to physical therapy and you didn't want to go. And this is the after effect. This is a consequence of that. So getting to a provider quickly, getting to the right providers and getting the proper treatment and going to that treatment, following through with those referrals, going to all of your appointments, you have to do that if you want to really put yourself in the best position to be successful.
Thank you, Samantha, so much for reminding everybody about these very important things to do right after the injury. How can plaintiffs best prepare themselves for the legal process in light of these new legislative changes and Medicaid procedures in the state of Virginia?
They can fully and adequately treat. Again, not self-discharge, not decide that it's too overwhelming or too inconvenient, because you're not going to be limited to that one tranche of money anymore if both parties involved in the accident have coverage. So you're going to have the ability to seek that help, to seek that medical care. You're going to be able to maximize that by getting the response back from Medicaid quickly about your lien, to utilize your Medicaid to get that lien amount back quickly. So it definitely changes the landscape regarding how your client should treat, how long they should treat, who they should treat with using their insurance. It definitely changes some of the nuances of it. So again, it's important to have an attorney for that reason, to help you navigate the system and maximize what you're doing to put yourself in that position for the best compensation.
What is one key takeaway, Samantha, you would like listeners to and viewers to remember about the importance of treatment in personal injury cases?
That's the only way that you are going to get what you deserve and what you are owed for the injury that you have incurred. To go quickly and to go consistently and follow through with everything. That is the best way to put yourself in a position to maximize what your recovery is going to be. That's the work that you have to put in to help us get you to that finish line.
Great, Samantha. I hope our discussion about the importance of medical treatment in personal injury cases, recent legislative changes in Virginia, provided practical advice for plaintiffs navigating the legal landscape was informative and educational. And as promised, here's a fun pop-up question for you, my dear. You ready?
Absolutely.
Who or what inspires you the most in your day-to-day life? And how do you incorporate that inspiration into your work?
Oh, that's a good one. There are a lot of people that inspire me. I think the people who inspire me the most are probably my kids. I have three boys. They're 9, 6, and my baby's 22 months. And just their viewpoint of the world, particularly in the legal field, I see so many people, the longer they practice, having this outlook of cynicism and that they're jaded and it's so negative and everybody's being dishonest and they're all just trying to take advantage of everybody else. And I see my kids who are just so open-minded and open-hearted and just have the see everybody with the best of intentions and in the best light and give everybody the benefit of the doubt and just approach the world from that perspective without all the weight of, living and practicing and how that kind of hardens a lot of people. And so I really try to put into practice how my kids view things and how they approach things and how they treat other people in their interactions because they are just so optimistic and it just seems to make all of those interactions so much nicer and kinder and gentler and even just to have the open sense of dialogue. If you're approaching somebody with a negative aspect or you believe that they're trying to do you harm or your client harm or this negativity, it just shuts down. You get walled up and it shuts down communication. So I think I really am inspired by my kids and just their open and honest approach to everything.
That's so wonderful. I hope your children remain the innocent, believers in this world because the world is beautiful and we need to appreciate every single second of our lives. How can listeners reach out to you, Samantha, or the Smith Law Center if they have more questions or need your legal advice or assistance?
So you can check out our website at smithlawcenter.com. Also, I'm happy to give out my cell phone. I love to talk to people. It's 948-205-1961, whether it's a prospective client, whether it's another attorney who's just, we like to partner with people and work together on cases. So most certainly I can always be reached those two ways. You'll find our phone number on the website as well as my email address. And even if you don't end up coming with me or working together. I always love to just help people. That's what I'm here for.
And I believe you have social media platforms like Instagram.
I do. Thank you for reminding me. I actually just started a page. It's RVA Accident Attorney on Instagram. RVA stands for Richmond, Virginia. That's where I live. So you can most certainly reach out to me on there as well.
I love it. That was attorney Samantha Cohn with the Smith Law Center in Hampton, Virginia. I want to thank you all for listening and watching our story today. For more tips and tricks on legal funding and personal injury law and medicine related topics, follow me, download, like, and subscribe to Time for More Injury Funding podcast on several podcast platforms worldwide, and follow More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google Business Profile, and my website at moreinjuryfunding.com. I can't wait to see you, my dear listeners and viewers, on my next upcoming episode. Until then, be well. Thank you.